Hello?
Okay.
Hello?
Good evening. My name's Suzanne Ryan, Chairman of the Zoning Board of Adjustments. It's September 8th, 2025. We have before us tonight two applicants. I'll open the meeting at 6:05, and I'll do the roll call. Suzanne Ryan, Chairman, is a voting member. Audrey Klein, Vice Chairman, voting member. Kate McMahon, voting member. Jody Persons, voting member. And Chuck Sumner, our clerk, voting member. I'd like to introduce this evening tonight, and Sabette Stroman is excused, she's an alternate. Introduce tonight, for those who were not at the last meeting, William Scott. He has been hired, thankfully, as our full-time planning director. And Shauna has been interim and very helpful. Thank you for coming tonight. And then we have with us tonight our planning zoning board attorney, Michael Malaguti, close, of Drummond and Woodsum. And at this point, I would ask the Chuck Sumner, our clerk, to read the site visit that we held at, 4 o'clock at the Atwell property.
Yes, we met at 14 Elm Street for the Atwell case. We met at 4 o'clock. Present were Suzanne, Kate, Audrey, Jody, and myself, all 5 members. For the applicant, Brian Underwood was there. We toured the property at 4 o'clock this afternoon. We located approximate boundaries and location of proposed parking spots. We left with a good general understanding of the proposed use of the site. Respectfully submitted, Chuck Sumner.
Okay, thank you, Chuck. And, excuse me. I always like to do a little comment in that the order of business. And as I said, we have 2 applicants tonight before us. And both sides will be heard. You'll have plenty of time, those that are for and those that are against, and then we go around again, and we will keep letting you ask questions and make sure that you get everything out that you want to get out and said. One thing that is important that people understand is that when the board votes and closes the public hearing portion and goes into deliberations, it's very rare that we will allow public comment after that. So make sure that if you think that the public comment period is winding down, that you get your last questions in, because when we deliberate, we will not open up the public comment unless the board votes to do so. And also, tonight, we are going to go about this a little differently in that the board will reserve its questions to the applicant and to the abutter until each has had an opportunity to speak. That way we get to hear both sides, and then we will ask questions. So, with that, I would like to read, as I always try to remember to do, the purpose of, 17562 Shorefront Residential. And the purpose is, the purpose of this district is to maintain the integrity of the existing shorefront residential district and protect the shorefront from overdevelopment. Further, the town recognizes the importance of implementing water quality protection standards in order to protect the shorelands within the town of Wolfeboro, since they are among its most valuable and fragile natural resources, and that the protection of these shorelands is essential to maintaining the integrity and exceptional water quality. Also, not to be forgotten, is 175 65 permitted uses. And in that zone, permitted uses are one single detached dwelling and accessory structures. Accessory structures specifically under C is boathouses and accessory structures in compliance with the following standards. And it's relevant to boathouses. I think that probably is my introduction. I would ask the applicants to go first, please, and state your name for the record, and please, the microphones are voice activated.
Do you want me to read the case first?
All right. Excuse me, just before you start to speak, I'd ask the clerk to read the legal notice.
The case is Atwell on Elm LLC, tax map number 204-008, 14 Elm Street, case number 11-V-25. Continuance of hearing for 3 variances under section 175-65 for expansion of non-conforming use, 175-67B for the natural woodlands buffer standards, and 175-64A1 for the front setback requirements of the Wolfeboro Planning and Zoning ordinances. Applicants requested continuance from August 4th, 2025.
Yes, and as I was saying, the microphones are voice activated. We have to really speak right into them, come up close to the microphones.
There we go.
Did that work? There we go. All right.
Tapping did it.
Good evening, board members. I have to slouch a little bit to make it, but I'll do it. My name is Roy Tilsley. I'm an attorney with Bernstein Shore, here tonight on behalf of Atwell on Elm LLC concerning the property at 14 Elm Street, tax map 204-8. I'm joined by Dr. Kerry Webster, who's the principal of Atwell on Elm LLC and operates the Atwell Acupuncture and Holistic Health Clinic on site. As you know, we are in the Shoreland Residential District. This is a property that has no frontage on any roads. We're talking here about a 7-lot parking area to serve an existing 2,200 square foot building, which is used for the acupuncture clinic and holistic health classes. Pursuant to determinations from the town, this is a pre-existing non-conforming use in this zone. My client purchased the property in 2022. She obtained building permits from the town to renovate the property for this particular use, which she relied on and did to nearly the tune of approximately $200,000. She also then obtained an occupancy permit from the town for these particular uses and has occupied the property for these uses for over 2 years, since July of 2023. I offer that because I appreciate that the abutters' challenge here, or part of their challenge, has been a suggestion that this use is not allowed. And from our perspective, we have the appropriate permits to occupy the building for this use from this town. And as far as we're concerned, the current state of the law is that we are allowed to use this building for this use. And the issue is whether or not we're entitled to a variance to add the 7 parking spaces to serve what is now an allowed use. And frankly, 2 years into it, it would simply be too late for anybody, whether it be the town or the abutter, to suddenly change course and decide that we could no longer use the building despite having all of the proper permits to do so. I'd ask the board to consider this variance request from that perspective, the perspective that this is an allowed use for this property, and I preach it's not allowed under the zone, but maybe I should rephrase that this is an authorized use for this property. And we are simply seeking to add parking spaces to serve what is an authorized use. We're seeking 3 variances. Section 175-67B is the natural woodland buffer. The entire area is already, regardless of whether we build a parking lot or not, it is not in the natural state. So the variance is required. I do know that there is some landscaping proposed on the plan to at least improve that a little bit. Second variance is 175-64A1 for the front setback. Again, there is no street frontage here, so it's a little bit of an unusual situation for a front setback. The property that we abut in the so-called front, the property owner is here today, and I anticipate that he will speak in favor of this variance application. And lastly, section 175-65 is expansion of pre-existing non-conforming use. The parking will serve the commercial use of the 2,200 square foot building. So the determination is that the commercial use is being expanded, and therefore we need a variance. I think it's worth pointing out for comparison's sake that normally the zoning ordinance requires on-site parking. The normal zoning ordinance requirement here is 10 spaces for this particular use. If the zoning ordinance was, if this was in a district where this use was allowed and someone wanted to build this building, this town would require 10 on-site parking spaces. So in many ways, while I understand and I'm not fighting with the determination that we need the variance for expansion of non-conforming use, in some ways we are making the property more conforming by providing on-site parking, which is a normal requirement in this town for this type of use, in order to serve the customers who are going to use the building and to help keep those customers off of other people's property and or off of public roadways for parking purposes. You should have, I believe, the plans. I didn't realize till later today that my surveyor engineer wasn't going to be here, so I don't have big ones, but I've got decent sized ones if anybody wants extra copies, but I assume everybody has. Great. So the proposal is fairly simple. You'll see the 2,200 square foot building in, I'm going to call it the front of the lot. There are an existing 3 parking spaces alongside the building. Those spaces are going to be striped, and that will allow us to create an ADA compliant space. And then we're proposing the construction of 7 additional spaces on the other side of the right-of-way that provides access to the abutter. Those spaces will be constructed, this is where I need my engineer, with permeable pavement, the kind of pavement that lets water come into it. I don't want to say it the wrong way. So there will not be any increase in impervious cover on this lot as a result of this proposal. We do have, at least for the initial proposal, the original design does have a shoreland impact permit from DES. I imagine that when we finish here and or with the planning board, there might be some tweaks to that, but the initial proposal was approved for shoreland impact permit. Lastly, we're not at this point proposing any new lighting for the parking lot. There is an existing street light in the vicinity, as well as lights on the building that we believe will be sufficient. I don't know what the planning board will require, if anything, but our proposal is not to add any new lighting in this particular area. As you all know, as I know, the abutting property owner, 204 Lot 7, is here to oppose this application tonight. That property is a residential property that is primarily used for short-term rentals. From our perspective, it's our belief that the addition of the parking will improve the situation between the properties in terms of who uses what. We've had issues with tenants parking on our property. We've had issues with people having access difficulties because there's not enough parking that people don't know where they're going. And we think that the addition of some defined clear parking to serve the 2,200 square foot building will help to improve the situation on site. To move to the variance criteria, this proposal is not contrary to the public interest and the spirit of the ordinance is observed. The ordinance, the spirit of the ordinance and the public interest all support the idea that uses should have on-site parking. It's a normal requirement of your zoning ordinance. We're proposing this parking in an environmentally responsible fashion with the permeable pavement that we believe will serve the spirit of the ordinance and is not contrary to the public interest. There will be a traffic benefit by taking users of this building who might be parking on abutting properties or parking on public streets off of those areas and having them park on the property in which they're receiving services. We also believe there'll be a public safety benefit by having on-site parking for this particular use. The third criteria, that was the first two. Substantial justice. Here, strict enforcement of the ordinance, the benefit to the public will be minimal. Again, the use is already here. It exists. We have all the permits we're required to have to operate this facility. Denying what would normally be required parking has little benefit to the public. The public wants to have parking on site. That's what your ordinance says. And it hurts the public by pushing parking off-site into abutting properties when there's overflow or even into the streets. The harm to the applicant is much more serious. My client's unable to provide a normally required expected parking for her customers. It handcuffs the operation of her business, and it creates confusions among the users, really, of these three properties, because you come in, let me get the addresses right. 204 Lot 9, and then the right-of-way goes to our property and then to the abutter's property. So you've got a lot of people using this area, and defining additional parking will, in fact, make things, I think, clearer to people who are using these areas and clear up some issues. The fourth issue is diminution in property values. I've got, if I could hand this out, if I can put my fingers on it. I've got a short letter from Randy Parker of Maxfield Realty on that issue, if I could submit that.
Thank you.
Thank you.
So as many of you may know, Mr. Parker is the owner-broker for Maxfield Real Estate. He has 30 years of experience in the Wolfeboro real estate market. Mr. Parker has opined after reviewing the property that he finds no negative impact on property values as a result of this proposal. He articulates a lot of the positive aspects of adding parking that I've been discussing so far. The fact that it keeps parking away from abutting lots or neighborhood streets. He notes that the proposed retaining wall, landscaping, and clearly marked spaces will be a visual and functional improvement over what's there now, that it will reduce congestion on the right-of-way that provides access to the abutting short-term rental clientele. Mr. Parker concludes that this proposal will not adversely affect the value of surrounding properties, that it will enhance neighborhood functionality and improve traffic flow along the right-of-way, and finally provide a more attractive streetscape. In his opinion, the proposal will actually increase abutting property values. Now, I appreciate that you have received, and he's here, so you'll likely hear something regarding Mr. Underwood's opinion, which is different than Mr. Parker's. If you've read his report carefully, I think Mr. Underwood's opinion is really focused on the commercial use of the property and not on the issue before this board, the addition of the parking area. The issue in this case, in terms of diminution, is not whether short-term rental properties' value is diminished by the addition of a commercial use next door. That use is allowed and approved by this town. The issue is, given the existence of the abutting commercial use in the 2,200 square foot building, does the addition of on-site parking to serve that use diminish surrounding property values? I think if you review Mr. Underwood's report carefully and compare it with Mr. Parker's, you'll agree with Mr. Parker that there's no diminution of surrounding property values in this particular case. The last variance criteria is unnecessary hardship. This property has at least two special conditions. One is the fact that there's no frontage either on the back bay on the water or on Elm Street. It's also a property that has been approved for commercial use by the town. There is no fair and substantial relationship between the public purpose of the ordinance and its specific application to the property. On-site parking is normally required by the zoning ordinance. Using the zoning ordinance to prevent something that would normally be required is not a fair and substantial relationship between the public purpose of the ordinance. And the proposed use is reasonable. Parking to serve a commercial type use on site is a reasonable use. We know that because it is nearly always required by this town when anyone has that type of use. It's being done in an environmentally sensitive way with pervious pavement. And again, we have a shoreland permit for the initial proposal. I'm confident that we meet all 5 criteria for the variance. I appreciate, I know I'm new to this game, that there's been some history with this application. We appreciate the board's perseverance in getting here to this point. But at this point, this is a straight variance application. We're not fighting about the history and this and that and the other thing. My client has the necessary permits from this town to operate the facility she operates. The abutters' opposition is based primarily on their challenge to that use. And simply put, it is too late, 2 years after my client has taken occupancy with the town's approval, for either the town or an abutter to challenge her ability to use the property for the purposes that she's been approved to use it. With that in mind, I think the question becomes much easier. The use is allowed, approved. The addition of normally required on-site parking does not deviate from the zoning ordinance. It serves the purposes of the zoning ordinance, and this variance should be granted. Usually I ask you for questions, but I'll hold that question until later. So thank you for your attention, and I look forward to talking to you soon. Thank you.
Thank you. And the Butters attorney, you're going to have to pull that microphone down.
Oops.
I think you have to unscrew it there and lower the whole shaft.
Perfect. Thank you.
Thank you.
A little bit challenged. Good evening.
You're going to have to speak right into the,
Right.
you're going to have to put your mouth right to the microphone.
Leave it. How's that? Is that working?
Yeah.
It's working for everybody? Good evening. I'm Rachel Hampy. I'm a civil
Yeah,
trial
you're gonna have to get,
Or?
it's voice activated, so like you see, I'm right up on top of it.
Okay.
There you go.
Is that better?
Yeah.
I'll lean in. I'm going to lean into this discussion tonight. I am Rachel Hampy. I'm a civil trial attorney with McLean Middleton. I handle land use matters, many of which recently have been in the Lakes region, coincidentally, but this is my first time appearing before you tonight, so it's nice to meet all of you, and it's a pleasure to be here. I represent Stephen and Suzanne Fetter, who you've already met at prior meetings. They're sitting here to my left. And we're also joined by our expert appraiser, Brian Underwood, who's sitting right there, and who was at the site visit earlier today. And just to start off, to clarify the record, this is not a short-term rental property. It's rented a couple weeks a year. It's a year-round residence, and in fact, the Fedders plan on retiring to it. The Atwell application fails to satisfy any of the 5 criteria for the variances it seeks. As Member Klein correctly pointed out during your April 7th meeting, Atwell never obtained a variance to change the former nonconforming use into the current nonconforming use, an entirely different nonconforming use, as a holistic health center and studio. Because Atwell's use is unlawful and nonconforming, you should summarily deny the application. And with respect to the issue about it being too late, your counsel can advise you on that, but a town is not allowed, or is not required to sit by over time and allow a nonconforming use that's illegal to continue to be existing illegally. It's not too late for the use to be contested, and as you know, we submitted a code enforcement complaint that is still pending before your town council for the code enforcer. So New Hampshire law does not support the expansion of a non-conforming use in this manner to an additional part of a property, let alone an unlawful one like this one. But even if the code enforcer or a court determines that this use is not unlawful, Atwell still fails to satisfy the criteria for a variance. There's specifically 2 criteria that it just, as a matter on its face, Atwell does not satisfy, but we'll briefly touch upon all of them. But in particular, Atwell cannot show that its variance does not violate the purpose of the ordinance. Specifically, the proposed expansion is in direct conflict to an unduly and marked degree, which is the court's terminology, with the core objectives of the shorefront residential district. And I appreciate the chair reading that purpose earlier this evening. In particular, the proposed parking lot would conflict with the 2 objectives of the shorefront residential district by allowing overdevelopment in the shorefront and by failing to protect water quality. These objectives serve to protect not just residential lakefront property owners like the Fedders, but they also serve to protect the businesses in town who rely on having good water quality to bring tourist revenue in town to support the businesses. These objectives have become increasingly important due to the occurrence of cyanobacteria in the lake in recent years. Atwell asks you to ignore these concerns and the negative impacts on abutters and other businesses to solve a problem of its own making in desiring to expand a business that was never permitted to be at this location to begin with. You shouldn't stand for it. You should especially not stand for it because even if the court does not issue a cease and desist order or the town doesn't issue one, Atwell can continue to exist in this specific location without the proposed parking. In other words, there is no hardship. It has available parking right next to it, and there's available public parking right nearby. Let's turn to all the criteria. The first one is it contrary to the public interest? And as experienced board members, you know that a variance is contrary to the public interest if it unduly and in a marked degree conflicts with the ordinance such that it violates the ordinance basic zoning objectives. To determine that issue, the court will look at whether the variance would alter the essential character of the locality or threaten public health, safety, and welfare. The proposed variances here do all of those things. Now, I've got a poster board here for you.
You can take the microphone out of the stand
I'll come back.
and then go over and read that if you want. You can pull that right out, the mic.
Well, I've got it written here, so
Oh, okay.
you all can see it.
Okay.
The purpose of the shorefront residential district is to maintain the integrity of the existing shorefront residential district and to protect the shorefront from overdevelopment and to maintain the integrity and exceptional quality of the waters. The signs on the way into town say America's first summer resort. So protecting the quality of the water is very important. And Atwell is threatening that by asking for variances from you to tear out the pretty much the last remaining vegetation on his lot. We provided this picture to show the area where they want to put the parking and how it's a downward slope towards the Fetters property and into the lake. And I'm going to provide you with a few additional handouts. I'm going to give them to you at the same time to make it more efficient. So one of the handouts that is being provided to you shows the culvert that we also just talked about at Exhibit 5 in our submission, our July 2nd submission. We submitted to you a picture showing rainwater going down the driveway heading in this direction, but now we provided to you a copy of a picture showing the actual culvert. So as it is, without the proposed parking, this area overflows and water goes into that culvert and then flushes onto the Fetters property and into the lake. And with 7 additional cars there's going to be more pollution, there's going to be more things running off the cars, and car pollution from the road and from the cars themselves going into that culvert and going onto the Fetters property and going into the lake. So in other words, the proposed variance is directly contrary to the core objective of the shorefront residential district, which is in part to protect the quality of the lakes. And that's important, as I mentioned, because cyanobacteria is becoming a reoccurring problem for the Lake Winnipesaukee and other lakes in the area, so much to the point that the governor has, the former governor, had money set aside, $1 million, to look into this problem. And as people know, that it continues to be a problem on the lake, and it's well known that storm runoff is a contributing factor to cyanobacteria. The other reason that the proposed variance violates the core objective of the shorefront residential district is because the shorefront residential district requires non-conforming uses to be reduced. And here, they're attempting to expand it and to tear out the little vegetation that's left in the area. And I have another poster board for you on that. That's section 175-67D of your ordinance. And in this section, property owners with non-conforming properties in the shorefront residential district, if they want to further develop the property, they're required to provide a narrative explaining how they're going to reduce the non-conforming use. And the method for doing that, according to this section that I have here in front of you, is they have to explain how they're going to reduce the overall square footage of the structural footprints and reducing the nonconformity of the existing, generally speaking, legally nonconforming use. Here we contend that it's illegal, but setting that aside, the whole proposal here is to expand the nonconforming use into a whole nother part of the property, which is entirely contrary to the core objective of the shorefront residential district. One of the other things the court will consider is how it's going to change the essential character of the property. And the proposed parking area of adding 7 cars is going to increase traffic, it's going to increase noise, it's going to increase light pollution. Even if they somehow manage to put in a parking lot without lighting, which rarely is allowed, it's going to increase light pollution from the cars themselves that are coming not just during the regular hours of a retail business, but during late nights and weekends when there's classes going on in the studio. So the unsightly parking area would significantly and negatively impact the essential character of this area and be directly in conflict with the objectives of the shorefront residential district. Turning to hardship, which is supposed to focus on the specific conditions of the property, Atwell cannot satisfy the criteria here. To obtain a use variance, Atwell needs to show that its proposal, that the zoning restriction applied to its proposal is unreasonable, and that there's no fair and substantial relationship between the zoning ordinance and their proposed development, and that the variance would not injure the public or private rights of others. And we'll address the third part in connection with the other criteria about the injuring others and injuring the fetters. But Atwell can't meet the other two. The use of the property as a holistic center and group studio is not reasonable considering the location of the property and the size of the parcel. It's especially not reasonable to operate a group studio on such a small parcel. And as you all know, as experienced board members, the issue is the condition of the property. The court will very much look at if the problem that the applicant is complaining about is a problem they created themselves. And that's what's happened here. They've put in a group studio in a location, a non-conforming group studio, in a location where there's no parking. And that's not a basis. Desiring to have more parking is not a basis to obtain a variance. It's not hardship. Because, first of all, there's parking there, and there's actually parking right nearby. And I have it, for the record, I know you all have seen it, but for the record, I'd like to provide a handout showing the public parking. So this is a photograph that I took of the public parking area that's an approximate 2-minute walk away. Now, I'm not particularly physically fit. I'm an overworked, stressed out lawyer, but even I can do it. And presumably people who are going to yoga class are there for fitness, and they could easily handle the 2-minute walk to the public parking area. So there's no hardship here because it's a situation that was created by the applicant. And in contrast, there's a fair and substantial relationship existing between the purpose of the ordinance and the specific restriction. As we talked about, the purpose of the restriction is to help protect the water quality on the adjacent back bay and to protect the residential character of the neighborhood. With respect to the requested non-use variances, Atwell can't satisfy the criteria for that either, because it would have to show that the property cannot be used in strict conformance with the ordinance. And as we discussed, that's simply not true. Atwell is existing currently without the proposed parking, and so it could continue to exist without the proposed parking. The third criteria, granting the variance, is contrary to the spirit of the ordinance. I'm not going to spend much time on that because by being contrary to the core objectives of the shorefront residential district, it is also contrary to the spirit and intent of the ordinance. Requested variances are contrary to the spirit of the ordinance because they will overdevelop the parcel, expand an unlawful, non-conforming commercial use in a residential district, and they will threaten water quality by introducing more cars and pollution along the shoreline. With respect to substantial justice, that will not be done by granting the variances. Certainly, there'll be no justice to the Fedders by disturbing their property, their paradise, their hopeful retirement property, by putting an unsightly parking lot right next to their boundary line, and by removing the last bit of residential character in the area. And as you know, the Fedders' only access to their property is through the parking lot. They have an easement that goes through the Atwell property. They and their 6 children, their foster children, their friends, and their other guests regularly use the easement to access their property. They use it to walk to nearby trails, let alone driving in there themselves. So the proposed parking will interfere with their easement by causing more cars to be backing out and in the way of their own entrance and departure from the property. But it also create an unnecessary safety hazard to them, their family members, and their guests, let alone, as we talked about, introducing more noise, light pollution, and pollutants close to their property. But the impact will be also on the community at large. There's no justice to the community, to the town or other abutters, or to the businesses who rely on good quality water to attract tourists if you allow these variances, if you allow Atwell to essentially tear up that last vegetation and thereby create a danger to the water quality in the nearby back bay. In contrast, Atwell doesn't have any loss because it's running a non-conforming use at an improper location with an available parking lot just a 2-minute walk away. That brings us to the last criteria, the impact on the surrounding, the value of the surrounding properties. You can rely on your own observations and your own common sense to understand that putting 7 more parking spaces right next to the Fedder's property line is going to negatively impact their use and enjoyment of their property. And it will similarly impact the value of their property and diminish it. It's going to basically turn the whole area into a mini office park, paving the whole, well, not paving, but creating an area for parking for the whole area. So it's going to diminish the residential feel and character of their neighborhood in a very significant and negative way. But you don't have to just rely on your common sense, because we have Mr. Underwood here, and I'm about to introduce him to allow him to speak to address any of your questions. But before I hand over the mic to him, I just want to say in summary that the proposed development, wait, let me just check, do you have anything you want me to add? Okay. The proposed development of the parking lot is contrary to the core objectives of the Shorefront Residential District. It would be an affront to justice to expand an unlawful, non-conforming use, would negatively impact the value and the use and enjoyment of the Fedder's property and easement, and there is no hardship because Atwell can continue to exist as it does and operate as it does with available parking in the area. The board should not be asked to address a problem of Atwell's own making, to support a use that should not be at this location and for which there already is an existing public parking area a mere 2-minute walk away.
Good evening. As Rachel indicated, I'm Brian Underwood. I was retained as a real estate consultant to determine whether or not there was a diminution of value to the Fedder property related to the variance application before you. And in the applicant's presentation, there was a suggestion that adding the 7 spaces on a 1/3 acre parcel that already has 2 buildings on it is going to make it more conforming. Well, 7 parking spaces on a 1/3 of an acre parcel in Wolfeboro on a shorefront residentially zoned parcel does not make it more conforming, it makes it less conforming. In terms of my opinion, it's before you. I'm happy to answer questions related to my opinion. I will just summarize it by saying, if you had 2 properties, all things being equal, same location, same house, same everything, but the only difference in that hypothetical situation is that one of those houses abutted a commercial use with 7 parking spaces adjacent to the boundary line, which property would you buy? Pretty much common sense. At some point, you would consider purchasing the one that has the parking lot next to it with the additional traffic activity, but you're not going to pay the same price than you would for the other property that doesn't. And if you can't get by that, you on your own have concluded that the proposed use and the request for a variance diminishes surrounding property value. Now, I will tell you professionally, I have been asked to opine on these types of cases and other instances where this is not the case. But we are not talking about a typical commercial property. We are talking about a parcel that is squarely in the shorefront residential district. And that makes it very difficult to compare properties A and B under the scenario I just gave you and conclude anything differently. I'll answer any questions if you have any.
I would just ask the board members, have you had a chance to look at Exhibit 3, which is the appraisal from the
Yes.
abutters? Okay. I'm trying to decide whether to have board members ask questions or open for public comment. I think we've heard quite a lot of information. I think I would like to start with some board members' questions and then any questions from the public, so we can get some answers and then public comment.
I suggest the public comment get made first, so that we can
You want public
integrate
comment?
that into
All
what
right,
we've
okay.
learned.
me too.
Okay, public comment then. By the way, we got a letter from a resident that lives in the neighborhood on 7/7. It came in last minute, and we never really, would you like a copy, each of you? We never really got a chance to even enter it into the record, and I actually just found it in my stack of papers, so.
We can share.
What?
So we can share.
Okay.
Take one.
Okay. It's from James Dagan. They say they own property on Center Street in Back Bay, south of 14 Elm, where a parking lot expansion is proposed for a variance. I appreciate all the business and character of Wolfeboro Falls. However, I have concerns for the commercial use of this residential property, potentially expanding with the addition of proposed parking because it is located between two other residential properties adjacent to Back Bay. And they're concerned about the hours of operation and traffic changes, increased parking, lighting, concerns about stormwater runoff into Back Bay and Winnipesaukee, algae bloom, goes into a whole paragraph about algae bloom in Lake Winnipesaukee and runoff. And then it says, my property and my neighbors have an abundant bedrock outcrop. Blasting could damage nearby structures, change the groundwater, chemicals. There have been many occurrences of groundwater contamination by blasting activities in New Hampshire. I don't know if blasting applies. That is entered into the record. Public comment from those in favor. State your name, please.
My name is Kirk Gilmore. I'm the managing partner of Celebrate Elm. We own 16 Elm Street, which is the first right-of-way when you turn into the parking lot. We bought the property back in 2016. In 2019, we bought the property that the Atwills currently own, so we were the sellers of that property. When our current property at 16 Elm is residential and commercial. There are 5 commercial units and 3 residential units on that property. I have 17 parking places in my parking space. In 2019, we bought the property that the Atwills currently have. At that time, I had gone before the planning committee and the building committee and checked about adding parking for the antique shop that we then opened. Previously to the antique shop, the Clickety-Clack Railroad Museum and attraction had been at that location since 1972. My property, even though this is residential at 16 Elm, has been commercial property since the 1950s. Everything from little stores to shoe shops to businesses. Right now, it's basically a medical practice for most of my clients. When I purchased the building, I was wanting to go ahead and put parking in. When I bought it from the previous owner, he said that originally they were approved to put parking into the hillside. I'd met with them at the town and did see an original drawing where there were supposed to be 5 to 7 parking places built into that hillside, and I was told that that would not be a problem. That was one of the reasons that we bought the property. When we sold the property, I know that Ms. Atwell was told the same thing. As far as the current use, you have my clients and my tenants who use it. You have Atwell's people who use it. You have the Fetters who use it. And you also have the town of Wolfeboro that nobody's brought up yet that uses the property quite regularly. There's a pumping station right behind the Atwell's property that is actually on the Fetters property that the town of Wolfeboro is there at least on a daily basis. They check it out, and at least once a week they're there running tests, which are very loud, very noisy, very smelly when they get the big generator running. A lot of times they've been blocking the entire way all the way to the Fetters house because they're doing work on the little station there. Also with the Fetters, when they've been renting it, while I was there were many times when their renters were pulled all the way up halfway down the building of the antique shop or the current shop. Adding parking will definitely alleviate some of the challenges that my tenants are currently having because right now, most of the time, they end up parking in my parking spaces instead of some of the other places. I don't have a problem with that. We don't mind sharing, but there are times of the day that between my clients and tenants and hers that it does get a little bit hectic. One thing is their business is not 24/7. Saturday mornings, a lot of times they're closed. Sunday mornings they're closed. In the evenings, they don't have business and classes going on that frequently and that often. Occasionally, it becomes a problem with our parking that they don't have parking and people parking in our spaces. But I'm over at that property on a regular basis, checking on my clients, helping with yard work, doing all sorts of things. And the number of times I go by the Atwell business and it's closed is interesting to me. It's not like it's a retail store where you have people coming in all hours of the day, from 8 o'clock in the morning till 8 o'clock at night. I'm definitely in favor of it, and it would, if anything, increase my property value, would not decrease my property value. Thank you.
Anyone else in favor? Like to speak? Anyone else opposed like to speak? Applicant, would you like to come back to the podium
Sure.
and maybe take some questions from the board?
Be happy to. Be happy to.
Is there anything you'd like to rebut right now?
Yeah, let me start with that as quickly as I can. The abutter opened with the idea that it was not too late for this town or them to challenge my client's existence. Well, it is. I mean, it's a doctrine called municipal estoppel. My client received permits from this town, relied on them, spent money, renovated the space, occupied the premises for 2 years now. It's too late for anyone to challenge that at this point. There is no law to support that type of challenge. I heard a lot about water quality in that presentation, but I never heard any evidence as to why this project is a threat to water quality. As we've told you, we've got pervious pavement, so we're not going to change drainage. The rain's going to get soaked up after this parking lot is built the same way it currently is. Additionally, I told you that we have the shoreland impact permit from DES, and you probably saw me scramble with my computer while they were presenting. The shoreland impact permit is created under RSA 583-B. Scrambling to find that statute, because that statute is the Shoreland Water Quality Protection Act. So we have the required permit from DES for the Shoreland Water Quality Protection Act for this parking lot. So I'm fairly certain if DES thought that we were doing this in an environmentally insensitive way, or in a way that would increase algae blooms or things like that in the lake, that they wouldn't have granted that permit. I have it. I only have one copy. I'm happy to submit it. I can go back to my office and print more in the morning if you'd like to see that permit. But I think that puts to bed any suggestion that we are doing anything that's going to be dangerous to the lake. There was a comment made about our ability to park. Oh, he left in the prior speaker's parking lot. He is kind enough on occasion to allow her clients and customers to park there, but there is no parking rights that we have. The only parking rights you have are the 3 spaces that currently exist next to the building. You do have clients who are handicapped, and getting from the public parking area can be problematic. That's, having now driven it a few times, that's not the easiest intersection in the world. The crosswalk is down the street a bit, so that's not a particularly handy place for people to park and get to this location. We are not proposing any increase in business. The business hours are going to stay the same. The parking lot's going to serve our existing business. This is not an effort to ramp it up. This business is closed on the weekends. The latest class runs to 8 p.m. And how often is that? Twice a month there's a class that goes to 8 p.m. That's, this is not going to be some 24/7 Las Vegas kind of deal out there. There was might still be up. So there was a section of the ordinance that you've had in front of you for a while now, 175-67D, on shorefront lot improvement standards. I think, and this is what I concluded, looking at it quickly, that that's a section that deals with non-conforming structures. So structures in this zone that don't conform to the dimensional requirements of the zoning ordinance, this applies to those. It does not apply to what we have here, which is a non-conforming use that is being expanded onto additional part of the lot. This is a use analysis, not a non-conforming structure analysis, and I do not believe that that section would apply. We don't have yoga classes. What kind of classes do we have? Tai Chi and Qigong. And they're up to no more than what? 6 to 8 people at a time. Getting back to the law, that's what I know. There was some comments made that, well, we can use the property in strict conformance with the zoning ordinance, and therefore there's no unnecessary hardship. That's not what I relied on for my argument. So as you likely know, there are 2 ways to prove unnecessary hardship under RSA 674-33. And one way is if you don't, I'm going to go backwards. I'm going to go to the second way because that's what opposing counsel talked about. If you can't show unnecessary hardship the first way, unnecessary hardship can still exist if the property cannot be reasonably used in strict conformance with the ordinance. And that's what you heard from opposing counsel. It's not what I'm relying on. I'm relying on the first way. And what I said in my presentation is that there was a special condition of the property that distinguished it from other properties in the area, both because it has what is a authorized use on the property, which is non-conforming, and because it's a lot that has frontage neither on a public street nor on Back Bay, that there was no fair and substantial relationship between the public purposes of the ordinance and their specific application to the property, because in our opinion, the ordinance favors on-site parking, requires it in most instances, and therefore to prevent us from having on-site parking is not a fair and substantial relationship, and that the proposed use is reasonable because, again, in nearly every instance, the ordinance requires on-site parking. I don't have to prove that the property cannot be used in conformance with the zoning ordinance to get a variance. And lastly, the landscaping issue on the pictures. I don't think it's fair to say we're getting rid of all the grass on the property. There still will be, I think if you look at the plan, you can see that there will still be reasonably grassed area. But in addition, we are proposing plantings around the parking area. You know, it's not humongous, I get it, but it's something. Again, this is a lot that right now, under the natural woodland buffer requirements, has none. And according to the engineer, when we're done, there'll be 180 square feet. So it's at least an improvement in that area. You know, we're probably not going to light off champagne corks and things like that, but it is an improvement. I think the idea that we're just paving this thing to smithereens is not really an accurate reflection of what we're trying to do here. And with that, I'm happy to take any questions.
Board members, any questions of the applicant? Or do you want to hear a rebuttal from the abutter?
I have no questions at this time.
Okay. Does the abutter's attorney have any rebuttal to what was just stated? I'm sure.
Point of fact, currently on the Atwell website, they advertise yoga classes and there are classes on the weekend. But more to the point, a variance runs with the land. So there would be nothing to stop Atwell or future owners from having classes all the time, constantly, 24/7. As it is, they're already having classes on off hours. And this is substantially more use than the actually approved use, which was originally for a museum, and then it became an antique store. That's what it was when the Fetters purchased their property. And now, as we point out, Atwell has converted it to a different, wholly different, non-conforming use without obtaining the necessary variance. And on municipal estoppel, your counsel can advise you on that, but those cases are really hard to prove, and I don't see that it applies here. But in any event, as I mentioned before, there's other doctrines having to do with the timing of when you can bring a lawsuit, and a town doesn't have to sit idly by and allow an illegal non-conforming use to continue to operate. But so here, that's what they're trying to do. They're trying to expand a non-conforming use that we say is illegal, but even if it isn't illegal, they're expanding a non-conforming use into a large vegetative area of the property, and that's contrary, directly contrary to the objectives of the shorefront residential district, which is specifically designed to prevent this kind of commercial creep into a residential area like this. And as we understand it, the proposed parking area will have a chain link fence and concrete blocks. And even if it's not paved, it's introducing cars to the property, to the area. So you're going to have rain bouncing off the top of cars that have the pollution on them from traveling wherever they travel, from the roads, their own oil leaks and other issues that they have themselves, and bringing that pollution into the area and allowing that to drain into the lake. The shorefront residential district is specifically designed to keep vegetation to prevent that kind of situation from happening. With respect to DES, we weren't involved in that. I'm not sure how it got through, but I'm familiar enough with the DES process to know that the DES counts on towns like you, boards like you, volunteers, doing your duty to protect districts like the shorefront residential district. And usually the DES approval says you can only go forward if you obtain the necessary town approval, which should be denied here. Well, I appreciate the owner speaking. He obviously has a vested interest because he sold the lot to Atwell, so he's not unbiased. And he has released one residential unit in his property. So it's going to be disturbing that residential unit as well. And while I appreciate that he and Atwell would like to have more parking, he himself said it's already hectic. It's hectic at times. So introducing 7 more parking spaces is introducing more hectic, it's intensifying that hectic traffic. It's introducing a safety hazard to my client, let alone an inconvenience and unnecessarily burdening their easement. I'm happy to answer any other questions or any questions you have.
We're going to turn it over to questions from the board. Jody?
Yeah, just for clarification, they don't reside at the residence right now? It's just for short-term rentals?
No,
They don't live there?
So it's a year-round property.
Yep.
They use it during the winter and the summer, and they
Okay.
only rent it for about 2 to 3 weeks a year. And they go
Okay.
there often, very,
Okay.
very, very often. They're there a lot.
And the dock slips on Back Bay, those are rented out, those are rental property, those are rental slips for the boats or your private boat?
Only one of the slips is rented, and the other 2, or what other ones are there, are used by them.
Okay, thank you.
Chuck? Any questions of either party?
No questions at this time, no.
Kate?
I don't have a question, I have a comment.
Well, we're in the question phase.
Okay.
Audrey, any questions?
No.
Well, I do. Maybe it was explained and I didn't catch it, but my concern is the elevation of the grade change from the grassed parking, from the grassed area to what will be leveled off for parking. I'm not clear on what that's going to be. I don't know as though it showed in the engineering plan the grade change? I'm trying to visualize what it will look like without grass and hot topped. And the grade or the elevation. Can anybody address that?
I'll try, but it's maybe not a whole heck of a lot. The retaining wall will be 4 feet high, just under 4 feet tall.
Well, you can't hot top over the grass, so something's got to be removed.
Right, the permeable pavement will be on, right, there'll be permeable pavement for the 7 parking spaces.
They're going to cut into the hill.
I'd like to
Yeah.
defer to Chuck because Chuck has some engineering background. Can you help me out, Chuck?
But they just said that there'll be a 4-foot retaining wall, so they're going to cut into that hill about 4 feet deep. And
Okay.
then what's left is the parking space. The parking slots will apparently be sloped slightly uphill.
So they're not changing the grade?
Yes, they're cutting in 4 feet, so
4 feet. So
the
what-
grade is 4 feet less than it was.
What visually, what does that look like? Is that like a wheelchair could go down that percentage of grade? What kind of a, to the right of way? I mean, is it 4 feet level to the right of way?
It's not quite level. I guess that is a good question. Would it be safe for a wheelchair?
Yes,
So there will be a slight grade on those parking spots.
Right.
Down to the right of way.
and not only that, the ADA compatible space is one of the existing spaces next to the building. So these, not that I think there's any issue with wheelchairs, but these spaces that'll have that little bit of a slope are not going to be handicap spaces.
So you're going to, at the top of the grassed area, you're going to come down 4 feet and put a stone, some sort of a retaining wall.
Yeah, a little less than 4 feet, but approximately.
It's shown on the civil engineering drawings.
What, Audrey?
The retaining wall is shown on the
I
civil.
know, I got the retaining wall portion, but I can't visualize what that grade is going to be. I just can't visualize what that grade would be. You have to use the microphone, I'm sorry.
They're trying to make it as flat as possible.
Could you introduce yourself, please?
I'm Dr. Carrie Hubbard. I am the owner of Atwell Acupuncture and one of the members for the LLC Atwell on Elm. Where you can see that grass on there, they're going to dig that as flat as possible. There'll be a slight grade, but not much of a noticeable one. They're going to build a retaining wall less than 4 feet high to hold that lawn back, and then the parking spaces will be within that. So the wall will go along the side, the front side, and then the spaces in between.
So they can't make it perfectly level, did you say?
That would all be in the engineer. I'm not going to pretend to be smarter than the engineers or even be able to read exactly what is there. I believe there is a slight grade to it as part of the design for the permeable surface.
So you're going to be removing soil off-site.
Correct.
Have you got an estimate how many truckloads that will be?
We've got to get past this part before we can start getting into that part.
Remember that the planning board is going to look at this, and I see that there's one place that it indicates a chain link fence, and there's another place that indicates a typical split rail fence. My assumption is the planning board is going to talk about the grade, the wall, the materials, and how it looks and behaves.
Yeah, I'm asking the question in part because of the safety of in the wintertime parking up there and then the drainage coming off of that area. If there's still a hill, there'll be drainage. If there's no hill and it's flat, then there wouldn't be so much drainage. So I'm just trying to find out. And I think it is under our purview to ask that question. And then okay, I see, go ahead. Go ahead.
For zoning purposes, it should be concerning to you that this whole area of this last vegetative area would be dug out with unknown amounts of digging, truckloads coming out of this area. And we submitted in our filing on July 2nd a picture of the rain coming this way down into this culvert here and out to the Fetters property. So there's going to be some sort of slope here, but already there's a drainage problem. And putting in parking is going to magnify that problem, whether it's sloped or flat. It's going to be magnified. And it's going to be magnified by having additional cars in there too, with water bouncing off the tops of the cars and flowing into this culvert that already overflows during rain events, and bringing that pollution into the lake. And your role in this, even if the planning board has final say over chain link fences and things like that, is to protect the core objectives of the shorefront residential district, which one of the main purposes, which you read this evening, and which I put on the poster board, is to protect the residential character of the area, which of course tearing out this grass would directly conflict with, because it's going to tear up the remaining residential character of the neighborhood. And the other core objective is to protect the water quality. So by introducing these cars and this area parking, you're going to add pollution to the overflowing culvert and allow pollutants to go into the lake, which again is one of the objectives that you all need to be focused on to protect the shorefront residential district. Thank you.
I have a question.
And who said that?
I have a question for the applicant's attorney. The shoreland impact permit that you said you have,
Yep.
does that apply to parking? Was that for specifically including parking?
Yes,
Okay,
that is
all
for this project.
Okay,
And this-
I just wanted
And
to
this
check that.
project is to add the 7 parking spaces
Okay.
and stripe the 3 existing spaces.
Okay, so that permit covers this parking?
Correct.
Thank
Correct.
you.
And I view the discussion we just had as a planning board thing, where the engineers talk to the engineers and, do the drain. I know that Norway Plains has done the calculations and all that type of stuff. So
Okay.
I really view that particular issue on drainage and the possibility that drainage will change as something that will be vetted by the planning board, as it always does,
Thank you.
hopefully without.
Okay, and then the reason I asked that question about how much is going to be taken out or what it visually is going to look like, because I think it was the abutters paperwork spoke about the view from the street through that property down to the back bay. Currently, it's all hot topped along the road, the frontage, the other abutter. And so now we'll lose that green space to hot top, number one. Number two, although lot coverage, there is a definition for how much lot coverage and a lot of that size can have. It's a small lot, I believe 3/4 of an acre, something like that.
Yes.
And now we're going to have more lot coverage. Number three, you have a state shoreland permit, but the town has its own more restrictive ordinance. And the town ordinance speaks to not just structures, but the lot. And you said something about structure. It speaks to the lot. And it also speaks to non-conforming, and I think it was something about reconfiguration. So I don't know as though you have met the town requirements.
I don't know what requirements you're looking at. No one has called us
Well,
out for specific town.
That would be under,
I mean, we're dealing with variances to 3 specific sections of the
that would
zoning
be under
ordinance.
the one you're asking for the variance. The shoreland, I don't know, I did with my agenda.
Natural woodlands buffer?
Yeah,
I mean, I think our argument there is already no natural woodlands buffer on the property as it sits today. So we are not making the natural woodland buffer any worse. We're actually, and again, I'm not looking for high fives for this, but with the plantings along the parking area, we're actually going to make it a little bit better and provide some of that, where right now none exists.
okay, so that's the one you're asking for the variance on the natural woodland buffer.
That's one of the 3,
Right.
correct.
Okay. Now, somebody correct me if I'm wrong, but it appears that what the applicant has done in their presentation and the abutters have done in response to that presentation have commingled the 3 variances together with your descriptions and your reasons and your explanations. But we are going to address each one separately. We're going to go through the 5 criteria of each one. It's not going to be a blanket motion to approve or disapprove.
Yeah, I mean, I think I mentioned it in my...
Is that correct?
I think that makes sense. I mean, in fairness to Attorney Tilsley, he's not the one who submitted the original filing. So I think that, yes, they're separate. You should consider them separately. But the narrative and the evidence that has been presented today should be considered.
Right, and I do think I did discuss the fact that there's already 0 lot coverage as the basis for that variance. We're not making it any worse. I did mention that while there is a front setback variance, this is not a standard front setback where the front fronts a road, it fronts an abutter who's supportive of this particular project. And then you get into the non-conforming use piece, which we did spend a lot of time on.
Yeah, and this is an unusual, the line here between planning factors and zoning factors is blurred because you have an ordinance that has performance standards in it, and it's not an overlay district, it's a general zoning district. And so it does blur that line a little bit, which is why there's been some overlap, I think, in a lot of the discussion.
Okay. I see you raising your hand. You want to address something?
I just want to quickly address this comment that it's not going to make it worse. It's going to be tearing up the vegetation that remains in the area that's currently preserving the residential character, which is an essential core objective of the shorefront residential district. It's absolutely going to make the area worse. It's going to turn it into a mini office park area with parking, and it's so much going to change the area that it's going to negatively impact the value of my client's property, as Mr. Underwood has explained in his letter and tonight in his testimony.
Madam Chair, if I can just make 2 points of clarification.
Yes, please.
Can you use a microphone so that they can hear you online?
What on?
He's going to use a microphone.
The two points of clarification are that, there was discussion about the DES shoreland permit. I think the way that I would encourage the board to think about that is that it's necessary but not sufficient, largely for the reasons that you pointed out. You do have independent standards in your zoning ordinance that talk about some of the same concerns, but others may differ. And so those are separate and distinct, and as far as I'm aware, the town's ordinance can be more restrictive than the state floor that's established by the Shoreline Protection Act. The other point that I was going to make, and I've forgotten the point now, It'll return to me, Madam Chair. My apologies.
But will it return in time?
And the town shoreland ordinance is 17567B? Question mark?
Correct. That is the portion of the ordinance that they're asking for the variance from, which is the natural woodland buffer standard.
And we seldom have requests for a variance with this type of situation. So I would suggest that we might want to open our books to 17567B. And take a quick look at it.
Can we do this during deliberation?
What's that, Audrey? Sorry.
Can we do this part during deliberation? Because I might have some things to say that this is.
Yeah, I suppose, but I'd just like the board to open their page to this and be prepared then. 17567B, and that is natural woodland buffer standards. And then within 150 feet for the line, and then you turn the page because then there are the standards.
Want some explanation?
Yeah,
So
nice and loud.
Yeah, so the way the ordinance reads, for lots that are less than half an acre between the reference line, which is the edge of water, and 150 feet from the reference line, at least 25% of the area between 50 and 150 feet must remain in an unaltered state. And the next section 3, for lots that do not comply with that area requirement of the natural woodlands buffer, the standards shall be satisfied using the following renewal standards. And there are standards there about replanting. And so they currently do not meet that 25%, and nor with this proposal will they bring it up to 25%, even though they are improving the situation by adding the 180 square feet.
And just so the board knows, that's contained, Norway Plains has an analysis on the left-hand side, that bottom box of the cover page of the natural woodland buffer standard, and you can see the analysis today is that there's 0, and with the plantings, there'll be 180 square feet if and when this project is improved and completed. So it improves that particular aspect of the situation.
So if I have this right, and maybe this will explain it, the natural woodlands buffer doesn't count grass.
Correct.
So grass areas is not natural woodlands buffer. So they need plantings, trees, shrubs, or ground cover to create that natural woodlands buffer.
And that's why
So they
we
can't-
have, I'm sorry, that's why we have 0 today, because we have grass,
Exactly.
but grass is not natural woodland buffer. So the plantings will add natural woodland buffer to the non-existent natural woodland buffer that's there.
So the natural woodlands buffer needs to be in an unaltered state. At the very end of the shoreland ordinance is the definition of unaltered state. Hardy and non-invasive vegetation, including ground cover, but not including lawns and annual gardens, allowed to grow without cutting, limbing, trimming, pruning, or mowing, or other similar activities except as needed to maintain health of the vegetation and renewal without damaging natural resources.
What section?
That's the very last paragraph of the entire shoreland ordinance. It's in section E, the very last definition, unaltered state.
Oh, okay, I see it. Yeah, thank you.
Yep.
So are you saying grass is ground cover?
No, grass is not.
No,
It's not.
Yep.
not.
Not including lawns and annual gardens.
but not including lawns, okay.
So as they said, there is no natural woodlands buffer presently. There's nothing there that would qualify as that. So whatever they're adding is more than what was there before, but not the 25%, which is why they need a variance.
So I will ask the interim planner, why did you call this out as something that needed a variance?
Because they're not bringing it up to the required 25%. So they're providing 180 square feet, but it's not 25% of the lot that's required under the ordinance.
Get it? Okay.
I see.
What does that mean in terms of percentages, roughly?
For what they are providing,
Yes,
I don't know.
it's a lot less than 25%, I assume.
Yeah, and I apologize, I don't, the applicant did not provide that, and I
Okay.
can't do that math in my head, I'm not that good.
Okay, one last go around.
So they're asking to tear up grass, which is still vegetation, even if it isn't woodlands, to introduce cars, pollution, parking, light pollution, and noise that negatively affects my client's property without even, and they're not going to improve it enough to put in sufficient woodlands in the area. They're going to negatively impact the value of my client's property, but they're also going to negatively impact the character of the area and negatively impact the water quality. So from a zoning perspective, they haven't met the criteria for a variance, specifically because they have no hardship. There's an existing parking lot, a public parking lot, 2 minutes away, a 2-minute walk away. Thank you.
All right, board members, any further questions of either the applicant or the abutters attorney?
I don't.
Last call. Okay. All right, I'm going to officially close the public hearing, and we will go into deliberations. Do I have a vote to do such? Audrey?
Yes.
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 Okay. So we will start with, what I do with my agenda. We have to go through the 5 criteria, and we will start with 175-65, expansion of non-conforming use.
The variance you're talking about is which variance?
I just said 175-65 for expansion of non-conforming use.
Thank you. The vegetation.
No,
Okay.
no, it's the expansion of non-conforming use. It's not the vegetation. They're adding parking.
Oh, okay. All right.
Where's my, get that, I want my, the first item that we have to address is I will make a note here. On the application, it says, are there any current zoning violations on the property other than those that may be listed on the application? If yes, please describe. Well, they put no, and I think that that's an error.
I don't think that's our place to make that
Yep.
determination.
Yep, that's not us.
All right, so we usually do number 1 and 2 together, and that was the variance will not be contrary to the public interest because the spirit of the ordinance is observed because. And I do not think that this application meets the spirit of the ordinance, and I do believe it is contrary to the public interest for the reasons as stated: more parking, more traffic, safety, expansion of commercial use in a residential zone. The shorefront residential is to maintain the integrity of the district and protect from overdevelopment. Overdevelopment of a small lot. They're confined to the size of the lot, and they're developing it. They've actually reached beyond the point of their business expanding. The public interest, I think it alters the essential, wait a minute, am I skipping? No. They would be altering the essential character of the neighborhood to a marked degree from, as I said during our public discussion, from the road, you would see what now is grass. You would see an unsightly parking lot rather than the view to the lake over the grassed area. There's increased congestion. I would say noise might be a factor, but I would say probably to the lesser degree, but I would say congestion definitely. Contrary to the public interest, expanding parking, not bringing a non-conforming use into more compliance. Our job, and the planning board's job, and the planner's job, and the code enforcement's job is to look at trying to bring things more into compliance, not the other way around. I see this going backwards. Those are my statements.
Okay.
Chuck?
I have a list. First of all, I live not too far away, and when I drive by there frequently, and more than once, several times, I've seen cars actually double parked in a single parking spot there.
Yeah.
So that they're really, it's an unsafe situation right now
Already.
where people are not parking properly. Yes, they can park down the street and across the street, but people aren't doing that. It's not real convenient, and it's probably not safe the way they're parking now. There's parking 2 cars deep in a single parking spot.
Just on 1 and 2.
Public interest, the drainage. We talked about drainage. I believe the impervious nature of what's put in place in the parking spots will be equal to what's there now. What's interesting is that what's there now is a hillside, so you actually, besides drainage, you also have water running downhill. You'll have less water running downhill because the hill is flat now. So drainage, I think, would be probably actually slightly improved. They're only taking about half of that lawn, by the way. If you look at the plan, about half of the lawn is consumed by the parking lot. The other half will be intact. And the plan calls for spruce trees to be planted around that parking lot. So it actually, if you do it right, you could dress it up and make it look pretty nice. You can't see it, by the way, they can't see that proposed lot from the house. You can see it from their property, but not from the house. It's like around the corner from their house.
From the street. Oh, sorry.
Those are my comments.
Okay. Kate?
I agree with Chuck. Also, you don't really see this lovely grass from the road, because what you see is the parking lot of the man that sold him the property. So you see mostly parking space. There is a situation of cramming and jamming and illegal parking right now, one car behind the other, parking along the grass. I think the addition of, or the approval of the 7 spaces is not going to create a whole lot more parking space, but it is going to be safer and cleaner and less congested. And I think the other thing is, I think that, in terms of the neighborhood, the appearance of the place, the neighborhood is mixed already. There are businesses, there's the spa across the street, which continues to enlarge its services. There was a hair salon, there's been a number of other businesses. I don't, it's a sticky wicket, because there it is, this island piece of property in the midst of the shoreline protection with no lake frontage and no street frontage. So it's kind of a unique situation. And, but I think that, the parking lot, a neat, orderly parking lot with some new plantings might very much improve the safety and the appearance.
I'm going to keep this short. I agree with everything that's already been said from Kate and Chuck, but I'd just like to add quickly that if you really look in there up at the top of everything, it's been paved over the years, all different kind of pavements, and I think they're all a lot of impervious pavement up the top and all the way down. I can't say that for 100% sure. So now I see that this parking lot that they're going to build is going to be the newest in, pervious and drainage, and I just think it's going to improve all the way around on everything. That's my thoughts.
Audrey?
I'm with these other three. I think, I don't just think, but I see a lot of projects, and I can say that from my experience, engineered stormwater collection and filtering systems are going to be better than what's already there. Right now, there's nothing, as a testimony says, running down the driveway. When you have impervious, it goes into the ground, it gets filtered. They may or may not have some collection areas when the planning board gets around to looking at this, that's going to catch that and treat it before it releases it. So I actually think that this is an improvement for the lake. It will be an improvement for the lake. So that's not contrary to the public interest, because I actually think this is a better situation. The spirit of the ordinance, I believe this is a mixed-use street, a mixed-use area in the Wolfeboro Falls. It's mostly business with some residential. With regard to the adjacent properties, the property that is, one property is behind the commercial building from this new parking lot, and the other property is up a steep hill and behind some trees, and I'm not even sure there's a house up there. So for the immediate area, I don't think that changes the immediate area at all. And for the broader area of Wolfeboro Falls and halfway up Elm Street, I don't believe that changes the area.
Okay, next one is number 3, substantial justice is done.
I think there's no question that the ability to run a business in this business location, in this commercial location that's been there for many, many decades, compared to adding 7 spaces, which can't be seen by the public, doesn't create runoff, improves the parking situation. I believe substantial justice is, with an approval, is given to this project and does not harm the public, the general public at all.
I agree.
I agree with that.
I agree.
I don't. What we have here is the overdevelopment of a residential shorefront lot and increasing commercialization in that specific area. And it is a residential zone. We keep forgetting to use that word. It's a shorefront/residential zone. And I do believe that the direct abutter uses most of that building for residential purposes. The town has voted on different times about trying to rezone it, and that gets defeated. The town has specifically tried to keep it in residential character in a residential neighborhood. The applicant could satellite parking as allowed by ordinance across the street. And I don't feel justice would be served in upholding the ordinance and the regulation. That's all I have.
The satellite parking, I'd just like to add down the street, there's plenty of spaces there, but some of the people that are coming for appointments for acupuncture or chiropractor or whatever, they're not exactly able to negotiate that. You know how that V is. There's a very busy street to cross. There's no crosswalk unless you go down to the Bridge Falls path. That's right. So that's really not a good alternative unless you're in really good athletic shape.
That's why we have ADA parking right next to the building for people that need that. All right.
I just want to point out that the direct abutter, I believe that you mentioned, uses his building for residential. That's a mixed-use building, so it has commercial and residential. It's not an apartment building or a duplex or something like that.
The values of, number 4, the values of surrounding properties. I have to say that I have never seen such a complete and thorough assessment of values as what we've received from the Feta side, the abutters. They left no stone unturned. So my vote will be dependent on, I totally agree with that assessment, the value assessment. I take that as a bona fide, qualified assessment, and that will factor into my vote.
So the way I came down to this was when the Federa's real estate agent was testifying, and he compared the value of the Federa's property now, the way it is, with to the value of some other property, some other place. And I don't think that's an equal comparison. I think it should be the value of the Federa's property now and the value of the Federa's property with 7 additional parking spaces next door. And I'm not a real estate agent, but I don't think the comparison was correct. If the parking spaces are impacting the Federa's property value, it should be compared to what the property was valued at before the parking spaces, not some shorefront property someplace else in town. So to me, you know, along with the fact that the Federa's do use their property with also people coming and going, I don't think that really impacts. I don't see that the comparison makes sense to me. So I can't agree with the Federa's real estate value assessment.
I think that Randy Parker's got considerable credibility in the town, and I am happy to have this in contrast to the 11 pages that were submitted on Mr. Underwood.
The property already has a good number. I don't know what the number is, but it's a good number of parking spaces there. Some of them are pretty ugly right now, no offense. Adding 7 spaces, I think if it's well done and the plan looks like it is well thought out, is 7 good-looking parking spaces that will be properly landscaped, and I think it would be actually an improvement in the area.
Jody,
Yeah, I'm going to just agree with Chuck.
you what?
I agree with Chuck, what he just said. That's.
Okay, I guess I lose that one. Number 5, literal enforcement of the ordinance would result in an unnecessary hardship. What did I have? 7 and 8. Somebody else want to go while I look up mine?
I will if when I find mine. So, special conditions. I can't think of any other lots that are sandwiched between a lot that's on the frontage and a lot that's behind it like this. I think that's quite unique. Does cause some problems, particularly with the setback, but with regard to the ability to use that property, this property was approved as a commercial property back in the day, and in 1984, the planning board approved it with these parking spots essentially where they are. They weren't built, but it's still a commercially used property, and it's now sandwiched between a multi-use building and a residential building behind that's on the shorefront. I do think that it's a really unique situation. I won't go on to the other second piece until anybody else wants to speak. It's also, it's unique in that it's required to have parking on the commercial site. And for all the uses that it's ever had in there, 3 parking spots was never enough. All right.
Kate, I'm sorry, were you finished?
I'm done for now.
Yeah, the uniqueness of the property certainly is a big consideration. I don't think that there is a fair and substantial relationship between the public purposes and what they're trying to do. So I think they meet the hardship requirement.
Jody?
They meet the hardship. I mean, that place has been there for decades. I mean, I don't know.
Yeah, I agree with what's been said so far in that they do meet the hardship requirements.
Okay, I don't believe that there is a hardship. I think that the purpose of the zoning restriction is they have to establish the special conditions of the property and the restrictions as applied to the property. And the special condition is no different than their abutters. They all have small lots. They all have, several of them on that side of the road have shoreland issues. I don't see anything special there. What I do say, and I'll probably get in trouble for saying this, what's new? So I feel that it's basically a self-created hardship. The applicant who bought the property in, what was it? What did I do with that piece of paper? Approximately 2022, yeah, I found my paper. And did renovations up and through 23, and stated at the selectmen's meeting that business was thriving, parking was needed to be expanded, and that there was a verbal agreement with the gentleman that spoke earlier to share parking. I think it would have behooved the applicant to get a written agreement So it was a miscalculation on a business sense of what happened. The shared parking agreement went away. There was not enough parking. And so now they come back and ask the town, do they have a hardship? I say they created the hardship themselves. And that to simply expand an unlawful use, in my view, that was not approved, did not have site plan, cannot be a hardship to support the use of a variance. That's all I have to say. Other than, I'll make a motion to, I'll make a motion to, where's my? What? Conditions? What makes you don't know what my motion's going to be? Well, I don't, but... No. I make a motion to deny application for section 175-65 expansion of use. I don't have the legal notice in front of me. Do you have it? The legal notice? Yeah, thanks. Thank you, yeah. For Atwell on Elm LLC, tax map 204-008, 14 Elm, case 11B. I don't even think I want to use that, 25. Do I hear a second to the motion to deny? Seeing no second, do I hear a motion to approve? And if so, we'd like to talk about some conditions.
I'll make a motion to approve.
Second.
You want me to read the case number? Motion to approve case 11-V-25, section 175-65 for expansion of non-conforming use. Personally, I think that the planning board and the Wolfeboro showfront permitting will take care of a lot of the issues that I might otherwise put in conditions.
All right, I have some conditions too, if I could find my drawing. Here it is. Okay, just hold on a second.
Did I get a second? Yeah. Oh, thank you.
I see regarding the fencing, where they're going to be digging out the parking lot, and it's noted as option, chain link fence or wood fence. I would make a condition that it be a wood fence and that it be heavily, because they don't give us a planting plan, I don't think, I guess they did, but that it be heavily planted from their abutters.
Can you quantify that, or I mean, how are they going to do heavily?
What? I'm sorry, Audrey.
Can you quantify what you mean by heavily planted?
To be screened so the abutters don't have to look at it.
Okay. I'm thinking hopefully the planning board.
I'm not a horticulturist, so I can't tell you what
Me neither.
species, but I think my intent is clear.
Okay.
And then, does anyone else have any other conditions? I would like to make sure, it was mentioned about lighting off the building. It would be sufficient, then if that's the case, that there be no lighting within the parking lot.
I would suggest that they could have ground lighting if they so chose, just no pole lighting.
What kind of lighting?
Ground lighting? Bollards?
If I may, Madam Chair, just give, if you'll entertain some brief explanation and advice about the kinds of conditions that could be.
Well, that's a safety condition.
So in general, conditions are permissible as long as they further the purposes of the ordinance. And I just offer that because we've talked a lot about the purposes of the ordinance. It seems like they're fairly discreet. And I just caution against attaching conditions that don't fall directly under furthering those purposes. Certainly the planning board will have jurisdiction to discuss lighting, but I think that that's one that strikes me that the board should discuss whether that is falls under those purposes of the ordinance that we've been talking about here tonight.
Okay, well then let me ask you a question. How do we know that this is going to the planning board for site plan review?
It has to.
It has to.
It has to, yes.
Okay.
And if, I generally advise boards that they don't need to attach that as a condition because it has to happen anyway, but if it will give the board comfort, the board can attach a condition that the applicant will comply with site plan regulations.
So can that be a condition of approval?
Yes.
Okay, so then I'll make that a condition of approval, that the applicant proceed to the planning board with the documentation that we received, and so that what we approve is what they look at. I know that's a stickler with you, Audrey.
Well, sometimes we say if there's a substantial change to the plan at the
They
planning
come
board,
back.
we want to have them come back.
back.
But it has to be related to what the attorney said. It can't be something that has nothing to do with what we
Right.
deliberated on.
But I want to make sure that the planning board gets the same plan and gets the notice of decision that we end up with and adhere to that. And,
For that end, we should read the date and the.
well, I was going to do that.
yeah, okay.
So I would add the condition that the plan submitted by the applicant of August 18th, done by Horizon.
I'm sorry, Norway Plains?
Who said that?
I did. It's Norway Plains?
These plans.
Yep, they're done by Norway Plains.
Norway Plains.
Norway Plains.
I haven't gotten that far yet. I haven't finished my sentence, which is, I was trying to put the date of the plan that we used, done by who, Horizon, and Horizon did one, Norway Plains did the other. I'm going to say both names. Horizon's name is on this one,
Norway Plains is
and
October
Norway Plains
24th.
is on this one.
It's a different date on Norway's Plains. That's last year's. Yeah.
Oh, I beg your pardon. Thank you for picking me up on that. I am so sorry.
So it's the plan.
So it will be
plan set.
Norway Plains, and it was dated,
October 24th,
what'd you
2024.
get? October 24th,
2024.
2024. Thank you for catching that, Shauna. I'm sorry. And then the other conditions would be all federal and state permits shall be received prior to construction, including but not limited to the town of Wolfeboro building codes. The approval is consistent with the material handed into us, received, including the materials that we received on, what did I say before? What was it date stamped? No, the date stamp.
March 17th.
That would be on the application. The date stamp's on the application. Sorry, the public hearing is closed. No, no, no,
Maybe if we just say as on file with the town office?
no, I want the date of the plan that was received. Things get missing, misfiled, and lost.
March 17th.
It's date stamped on the application.
The application is March 17th, but the plan is October.
That's what I want.
Okay,
Yeah.
March 17th, the application of March 17th, 2025.
Yes,
Correct.
that's the original
Yeah.
application, March 17th, 2025, and the plan was done by Norway Plains, October 24th, 2024. So those dates are important because those are the official documents. The application as submitted to the ZBA does not satisfy the submittal requirements for the building permit or site plan approval. The notice of decision shall be recorded at Carroll County Registry of Deeds, and the applicant shall be responsible for payment of such, and I believe the town records that, but the applicant pays for it.
Correct.
The variance shall be valid if exercised within 2 years of the date of approval or as further extended by local ordinance of the Zoning Board of Adjustments for good cause in accordance with 674-33-1A appeal process pursuant to RSA 677-2. There's 3 different RSAs here, 677-4 and 6796. Any aggrieved party may appeal their decision, and one is to the County Superior Court within 30 days. The other is they may appeal back to us, or they may appeal to the relatively new New Hampshire Housing Board of Authority. And then I think, as we say, is there any significant change to the site plan that we get it back, that we get it's returned back to us? And we did, this is nothing new. We did this on August 4th at another application. And so I think I've had it. That's the conditions. Do I get a second for the motion as conditioned? It wasn't conditioned at that time. Do I have a second for the motion as
Second.
conditioned? Yes?
Yes.
Roll call vote. Audrey?
Yes for approval.
Yes. To approve.
Yes, to approve.
No. Deny.
Yes to approve.
The motion passes 4-1. Thank you.
One down.
That's it. Everyone can go home now.
No,
We got
that's-
2 more.
No.
2 more variances.
Two more variances.
More variances.
Oh, shoot, I forgot. Oh.
And we have another case.
Natural
Yeah,
woodland
all right.
buffer.
No wonder everybody looked kind of funny at me. Okay.
All right, so this would be,
No, we got to do, Chuck's got to read the legal notice for the second one.
I was going to, but Chuck, go ahead, Chuck.
I read basically all 3 of them.
Well, it wouldn't hurt to
All
have
right.
it in the minutes in order of how they appear.
Because,
So the legal notice is for the second one, which is the natural woodland buffer. I think,
Yes.
wait, yeah.
yes, Atwell on Elm LLC, tax map 204-008, 14 Elm Street, case number 11-B-25. Continuance of hearing for the second variance of 3. This one is for the natural woodlands buffer standards requirement, variance from 175-67B for natural woodlands buffer standards. That's the second of 3 variances requested.
So, Madam Chair, what I suggest is that the board accept the testimony from the first variance and really focus the deliberations on the second variance and then the third variance.
Can I ask a question, though? Because the natural woodland buffer is for a half acre or more?
So in the ordinance, it is section 175-67B for lots that are less than half an acre between the reference line and 150 feet from the reference line. At least 25 of the area between 50 feet and 150 feet from the reference line must remain in an unaltered state.
So on the plans under what they wrote, and maybe this says the same thing and I'm just not processing it, says total area between reference line and 150 feet from the reference line is more than a half an acre, at least 50% of the land between 50 and 150 from the reference line must remain in an unaltered area. So this kind of says that it's only for properties that are more than a half an acre. So maybe that's wrong, but does it say the same thing as that?
And I may stand corrected, I went with the less than half acre because that's what was stated, and I apologize.
Yeah.
What you read is the other piece of that section of the ordinance, which is for lots that are half an acre or more in size between the reference line and 150 feet, at least 50% of the area between 50 and 150 must be maintained in an unaltered state.
Okay, so they referenced really the wrong part
Yep.
in here for the lot. Gotcha. Well, darn. Let's see.
Okay, so let the record reflect that we take the testimony as previously given as our official record. And I will open the public hearing for those of.
No, I don't know that we need to do that anymore, so we're just going to do deliberations. We're just going to go over the criteria.
Yeah, but don't we just ask the public if they want to speak on this?
No?
Everybody spoke to.
Oh, they spoke to all
Yeah.
three commingled in?
Yep.
They had them all together.
Yep.
Okay. Okay, so I'll close the public hearing and we will go into deliberations. And I will start with number 1 and 2. The variance is not contrary to the public interest and the spirit of the ordinance is observed. I guess I better pull out my Okay. This is something we're not that familiar with, as given by questions we keep asking about it. Okay, going to open up your book.
So it's 175-67. B. 175-67B.
For reference, this, I just looked it up, this lot is 0.4 acres.
This says 0.36 acres.
Okay, the tax map, I guess, rounds up, but it's, so it's less than a half an acre.
Yeah,
Yes.
that's why I was questioning what I was reading on here.
So Chuck, you want to go first on the variance contrary to the public interest and the spirit of the ordinance? And does the purpose must not conflict with the explicit or implicit purpose of the ordinance and must not alter the essential character of the neighborhood, threaten public safety, health, or welfare, or otherwise injurious to the public rights. and then spirit, as it is in the public interest to uphold the spirit of the zoning ordinance, that these criteria are related.
So, yeah, we don't meet it now. What I understand is that by doing the plantings that have been proposed around the parking lot, they will actually improve that number that's required.
And it looks here like the proposed trees are 4, and I see them on the plan around the proposed parking area. And the proposed shrubs are 1 per 4 square foot. Well, looks like there's 9 shrubs. I don't know if that lines up with the numbers because I'm not mathing tonight. But I think similar to some of our shorefront regulations, when you're starting with something, you know, bad and you're making it better, sometimes you don't have to meet the perfect number. Don't let the, what do they say? Don't let the perfect interrupt the good or something like that. So again, I think if the planning board feels like it's possible to have more shrubbery, or they should have more shrubbery in order to create that buffering. If you remember when we were on there, there's a number of pretty interesting large shrubs or small trees on the property line that already do buffer a bit. And also, that's the back of the house, whereas the side and the front of the house face the lake, which is where you're likely to mostly be looking.
Kate?
Well, the property's already in an altered state, the land and the surface, so I think that, and also the grass doesn't count as natural woodlands, so I think that the improvements, the addition of shrubs and trees will, in the right direction, even if it doesn't meet the letter of the law, is good. So I think it meets the requirements.
Jody?
Well, you got that whole grass area. That whole grass area has nothing now, so adding those shrubs in around the parking, I think, is appropriate.
Chuck? Yeah, okay. Well, I would say that I do not agree, and that part of the purpose of the ordinance is to protect the shorefront from overdevelopment, and I feel that this parking lot will add to an already congested, overdeveloped 2 parcels. Okay, so then the next one is values of surrounding properties.
Creating the buffer can only increase.
Well, we got to do the 5 criteria, right?
That's what I was
That's what
saying.
she's doing. That's what she's addressing.
Which you just said, right?
Yeah, what are you saying?
I'm saying adding the vegetation in the natural woodlands buffer can only increase the value of the surrounding properties. It's not going to decrease the value.
Kate?
Agree. Adding, adding vegetation and trees will increase the value.
I agree.
Well, of course, I disagree. I think that if we didn't allow the parking lot in the first place, we wouldn't be talking about a buffer. So I don't think that buffer adds value to the overall site, meaning the abutters in the front, and the abutters in the back. What you're still going to have is a parking lot with 7 cars, with some trees and a wooden fence around it, rather than grass. So I'm not in agreement, and as I said, I think it's one of the finest examples of value that this board has ever received in the decade that I've sat on it.
Chuck?
This particular variance is just the natural woodland buffer. With respect to that, I think what is proposed is an improvement over the current situation. So I'm in favor of that.
Okay, number 5, little enforcement of the ordinance would result in unnecessary hardship. Unnecessary hardship can be shown in either of 2 ways. That the special conditions of the property distinguish it from other properties in the area. And the proposed use is a reasonable one.
Well, one of the special conditions.
Wait, Audrey.
Sorry.
Oh, I was going to say, in terms of feeling that the variance for the less than 25% can be granted, I don't see that more than what's provided here provides any more screening or benefit. So I don't think the application of the criteria of the hardship ordinance really applies to this particular situation.
Well, there's another special condition. I know this is all under the shorefront, but behind the building, you've got the pumping station, you've got structures from the town, which you can't put any plantings in there. I mean, there's an obstruction, so I think that's part of the hardship.
Good point.
I got nothing.
Chuck?
Well, based on what I'm looking at, you have 2 buildings and a right-of-way and existing parking lots. I mean, you can't get there from here. You can't get to 25%.
No.
So what we're doing is, an effort towards that, but we can't reasonably get there. So I think what they're suggesting is adequate.
I would say that I do not believe that there's a hardship, and that this use will alter the essential character of the neighborhood. Okay.
Madam
so-
Chair, I'm so sorry to interrupt because I know you guys are booking right along. I think you missed substantial justice, so I just want to make sure
I
you hit
missed
a
one?
couple.
I'm sorry.
Sorry, we need to be thorough on this one.
All right, substantial justice is done, that's number 3.
There's-
The benefit to the applicant should not be outweighed by the harm to the general public.
I don't believe there's any harm to the general public in the amount of allowing a variance for less than 25%, given that they're adding more than that was there, and it appears to be adequate for screening purposes, and creating, because they're creating the stormwater drainage system, there's no room in that area to add more vegetation in any case.
I agree.
I agree.
I agree.
I disagree. I'll state what I stated before, that I believe that this overdevelopment on residential shorefront is increasing commercialization, and in this specific zone, and even putting buffers and fences and so forth is not going to satisfy the character of that particular area. All right, so a motion, we had a
I
motion.
make a motion to approve variance, case number 11-V-25, section 175-67B for the natural woodlands buffer standards.
Second.
Second.
with conditions.
I think if we can just use the same conditions as far as the application and the plan that we had on the first one, those are the only conditions that I would place on this.
I would agree to those conditions as previously stated. So the motion is to grant with conditions as previously stated. And do I have a second?
I'll second that.
Who did? Chuck did. Roll call vote.
Audrey, yes?
Kate, yes.
Jody, yes.
Ryan, no.
Chuck, yes.
Okay. Now, are we on to the next one?
Yes.
Yep.
Almost there.
Okay, we're
Like
getting
three-quarters
there.
done with the marathon.
We're getting there.
So shall I read this one too?
Yeah, wait a minute. Oh, where the heck did I do with it? Oh, it's right here. All right, so the last one for this application is 175-64A1 front setback.
You want to read
Yes,
it?
please read the legal notice.
Atwell on Elm LLC, tax map number 204-8, I'm sorry, -008, 14 Elm Street, case number 11-V-25. Continuance of hearing for a variance under section 175-64A1 for the front setback requirements of the Wolfeboro Planning and Zoning Ordinance. Continuation from August 4th, 2025.
Okay, and again, with this application, we will enter into the record the applicant and the abutters presentation and not have to have it repeated. So we go right into deliberations, which would be the 5 criteria. What did I do with mine? Chuck, why don't you start us off? Okay. The variance will be not contrary to the public interest and the spirit of the ordinance observed because. Audrey, you want to start us off?
Yep. This area is already largely covered with commercial activity, including pavement. I don't think from a public standpoint, driving past this and looking at this area, that these spaces down here make any visual difference to me. Again, I think that the runoff is treated better than it will be, than it is presently. It's being managed where right now it's just flowing down, apparently flowing down the driveway into the lake. I think it's a better situation, and I think that's public good, and I don't think it changes the neighborhood, which is at least half commercial, and particularly in this area, already quite built up.
Kate?
I don't see any impact negative to the public on this. I don't see really any change, except a better look.
Jody?
I would say, yeah, it's basically, I think it's gonna look better going by. It's gonna hopefully decongest the parking in there a little bit, so it doesn't look like a bit, a big mess, so.
It's a pre-existing non-conforming lot. I don't think that we have a whole lot of choices on this one.
Yeah, I agree.
Okay, so we'll skip to number 3. Substantial justice is done. The benefit to the applicant should not be outweighed by the harm to the general public.
The difference between, meeting the setback and not meeting the setback is not going to make any difference to the public at all, but it's going to allow for several more parking spots for the business.
Yep, agreed.
Jody,
Agree.
Ryan, agreed.
Agree.
The values of surrounding properties, number 4, are not diminished. I'll lead
Again,
off
I
with the-
compared it, you know, the values of the surrounding properties without the 7 spots versus the values of the surrounding properties with the 7 spots, I don't think is significant at all.
Neither do I.
Jody?
Agree.
Well, I do believe that the values of surrounding properties are affected by this, so I do not agree. Go ahead, Chuck.
I agree with, I agree with Audrey.
Okay, so, motion?
Hardship, hardship.
Hardship.
Oh, I'm getting tired. Hardship,
Again, the
Number 5.
special circumstances of this property is it doesn't have any actual street frontage. And the side that we're talking about, the front setback, is actually right next to a commercial parking lot. So to restrict that because of the setback makes no sense in this situation where it's already all parking lot essentially. So the hardship is it's a lot in the middle.
Kate,
The proposed use is reasonable.
I'm with Audrey.
it's the special conditions of the property that cause the proposed use to be reasonable. But it says, must not alter the essential character of the neighborhood, and I go back to that again and again. This project does alter the essential character of the neighborhood, so I disagree. Go ahead, Chuck.
No, I don't have anything to add to this other than what's already been said by Audrey and everybody but you.
Okay. All right, so anybody want to make a motion on this variance? I believe this is the last one on this case. I see Shauna shaking her
I
head.
would make a motion to approve case 11-V-25, section 175, 64A1 for the front setback requirements of the Wolfeboro Planning and Zoning Ordinance using the plan and application dates that we have from the previous 2 variances. And that's all I would put on that.
Well, and did you
And-
say the same conditions?
And with the same conditions
Same
as
conditions as we,
Which included the dates and so
Same,
forth?
same conditions, yes.
second.
Okay.
I'll let-
Jody seconded.
Okay, roll call vote. Those in favor?
Audrey, yes.
Kate, yes.
Yes.
No?
Yes.
There, now we're done, and
Could we take a break?
you've got your approval,
I need a break.
and there you sit.
I don't care, but they do.
Thank you all for your patience.
Right. I asked for a break, but it depends on whether we're stopping at 9.
We're going to stop at
What's
9.
that?
I wanted to take a break, but are we going to pick up another case and finish it? Or are we going to stop at 9, or what are we going to do?
See anybody
Yeah,
here?
there's nobody here for that case that I see.
We're going to stop at 9, aren't we? We've been working since 4.
Anybody here for that case?
I don't see anybody.
Christ.
Well, I mean, we have to open them and continue them.
I'm going to continue it.
Just because they're not here doesn't mean we can ignore them.
We'll take a break.
Take a break?
All right,
Yeah, 2 minutes.
okay.
Quick.
Hey, nice.
Shoot, man.
There's 5 of us here, okay, Audrey? You too? There's 5 of us here, just keep going.
Okay.
Okay, are you on? Oh, thank you very much. Okay, so the second half of this evening is for a variance and a special exception for a parcel over on Sewell Road. And there was a site visit conducted this evening. And Chuck, would you be so kind as to read the site visit and the legal notice?
Yes, I will. Four board members were at a site visit at 48 Sewell Road. Kate, Audrey, Jody, and myself. Suzanne was excused. Nobody was there to represent the applicant at the time we were there. We toured the site at 4:30 this afternoon. We observed where the proposed deck would stand. We saw the porch, which would support a new second-floor expansion. We left with a good general understanding of the proposed use of this site. Respectfully submitted, Chuck Sumner, zoning board clerk.
And the legal notice?
The legal notice, the first one is Michael and Tamara Slode, tax map number 217-113, 48 Sewell Road, case number 19-SE-25.
Chuck, hold it right there. I'm going to change the order and do the variance first.
Okay, so for case number 20-V, oh, this is a new case. For the variance, it is case number 20-V-25, 175-43-1, application for a variance, expansion of a second floor above footprint of an existing closed porch.
That's not
And
what I
then, as I
remember seeing.
usually do, read the purpose under 175-43, non-conforming structures. This is not a non-conforming use, this is a non-conforming structure. And the purpose of this section is to establish and distinguish between permitting requirements with respect to building permits, special exceptions, and variances regarding expansion or extension of existing non-conforming structure. That's about it. Okay, I'm going to open the public hearing. And would the applicant please state his name?
Thank you.
Yeah, no,
Yep.
we're going to do the variance first.
No, he's saying that there's a misprint on the description.
Yeah.
So we noticed that, and thank you for confirming that. It's expansion of the deck, not an expansion on the second floor above the deck.
Okay. And okay, and you can either go through the 5 criteria as outlined on your application, or you can ad lib.
Hang on just a second, Bill. This is the one that came in my packet. The B and C are, yeah, except for the numbers are different, so it'd be nice to know which one is which. Oh, right. Okay, so 175-43-1C is the special exception. We are.
So is the agenda right? Is it, is one of these right and one of these wrong, or they're both wrong?
One is right, one is wrong.
Which one's right?
Reference zone. Yeah.
No, which document?
This is it's accurate for
This one is right.
variance. It's good for the variance.
175-43-1C is for the special exception. And
I is for the variance.
175-43-1C is the special exception. I think I've got the same copy. I have,
No, it's 140, it's 175-43-A1I is for the variance. A, I.
Well, I guess the question is, was it advertised correctly? That's all right, I'll go,
I don't get it, but as long as whoever reads it into the record has it right.
Oh, okay.
Okay.
There it is. It's I.
Yeah. 1I. Yeah. Okay. Got it.
we're just gonna do the variance first.
Okay. Sorry. I got it now. So we're going to do the variance, which is extending the deck.
Speak close to the microphone. Did we get one of those? Did we get one of those?
Yeah.
Yeah.
the one that you were reading before from her.
Oh, right, I just put it up there. No, I'm gonna get
So, can I ask a question? I was wondering till you got to the very last sentence, will be offset by a decrease in the patio area. So when I read that, I think you're going to remove the impervious patio from under this new deck, and the deck is going to be pervious. It's going to have, the rain's going to go through the deck. I'm aware of their definition, but the second half of their definition says, unless it's designed to allow water to go through. So they changed the definition because people were skirting around what they really wanted. Right, exactly. The people do it, though. They'll do a concrete slab or something. I get that, but if you were to remove the flagstones, you would be improving the project by... Oh, there's no requirement, but you are asking for a variance, right? Okay. Okay, so if it's staying the same, why would we need a variance?
Extending into the setback.
Yeah, I recognize the distances. Yep. So going to your special conditions, kind of a stickler thing for me that I've said several times to this board. If your special condition is the reason why you need the variance, then everybody who asked for a variance has a special condition and every variance would be granted. It's a circular argument. Now, I do agree that your special condition might be that you have impervious already under this deck you want to expand. That could be considered special. It's different. Bill, do you happen to know what our definition of impervious is? Never mind, I've got the definitions here. I just wonder if it's different than the state's.
Question I have is, what is the setback that the deck is from the back corner of the extended?
It's very small. It's the definition section. I wish we had page numbers.
It's in the definition. In the definition, Audrey, impervious surface, is that what you're looking for?
Yeah, here we go. Any modified
modific-
service, you want to read it, or?
Oh, any modification, any modified surface that cannot efficiently absorb and infiltrate water. Examples of impervious surface include, but are not limited to, roofs, decks, patios,
paved.
and
Okay.
paved gravel or crushed stone driveways, parking areas and walkways, unless designed to effectively absorb or infiltrate the water, RSA 483B.
So it's that second part that I think they changed the definition because people were calling concrete slabs decks. You know, impervious decks because they were not covered, they were outside. And so they added, unless they effectively absorb or infiltrate water. And a deck with, in my opinion, a deck with spaces in between the boards allows the water to go down and hopefully into the ground, not on a patio. So just, that's annoyed me for a long time because I used to work before they changed that definition. Right. Those are all my questions.
So I'm still not clear what the hardship is.
Well, I think one could say, although we just talked about it, it could be that, oh, it's not really a hardship, it's a special condition. I'm not going to answer that question. That's for you.
Literal enforcement of these provisions of the ordinances will result in an unnecessary hardship. What is the hardship? Well, you already have a smaller deck that provides an entrance into, like a back door, I guess. So, right, and it's going to continue to be just an entry deck, I believe, right? So the hardship is that you can't fit a chair on the deck? It is, and I don't mean to be difficult. I kind of like the design, but I don't understand the technical argument here.
So I think if we go to the part where it says no fair and substantial relationship exists between the purpose of the ordinance, which is to not create more impervious area, not to clutter the shorefront with more construction that you're looking at, you know. Those are the types of things, if this doesn't, if the relationship between the purpose of the ordinance and this proposal isn't connected, then the ordinance doesn't really apply to what they're asking for.
Okay.
So I would say that if you use that no fair and substantial relationship, if we were looking at, a property that was on a very pristine shorefront, and they wanted to add more in that 50 feet that we're looking at that's closer to us, that would maybe be a no, because the purpose of the ordinance is to not develop in that 50 feet. In this case, they're on a very prominent point with lots of construction that's already a visual, movie of the front of the lake, and their little part that's getting closer is not changing the neighborhood at all.
Okay. Yeah, no, I can agree with that piece of it.
Yeah, I agree too.
Well, I'm kind of stuck with, it sounds like he's saying, his special condition is the same as his neighbor's, or will be when he puts the
The
addition.
special condition is that he's within the 50-foot setback.
Is this what?
he's within the 50-foot setback is a special condition, which is not a special condition, because that's why you have to ask for the variance. You can't have the variance request and the special condition be the same thing.
So do you want to proceed with this and that?
Well, I think the special condition could be there's already impervious area under there, so if he was adding more impervious area, that would be a different situation.
But is he?
No. I don't think his reasoning for the special condition makes sense.
So there's no public here tonight for or against. So would you like to close the public hearing and go to deliberations?
Sure.
Okay, then I'll make a motion to thank you for your testimony. I'll make a motion to close the public hearing and go into deliberations. Audrey?
Second.
Yeah.
Yes.
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 Okay. So now, let's go through the 5 criteria and see how, if they meet the hardship when we get to number 5. But let's go with number 1 and 2. Contrary to the public interest and the spirit of the ordinance is observed. Given the way you described it, I can't see that the spirit of the ordinance is observed.
What is the spirit of the ordinance in your mind there?
I lost my page.
I think the spirit of the ordinance is not to perceptually overcrowd the shorefront.
How many square feet?
Perceptually.
Not going to do it.
A1I, any proposed construction.
175-43.
A1I. A1I.
Any proposed construction activity located within a setback area with further encroachment shall require a variance. But then expansion and extension. The purpose of the section is to establish and distinguish between permitting requirements with respect to building permits, special exception and variance regarding expansion. It really doesn't tell you
The
anything.
purpose, you have to read that from the shorefront, shorefront zone, purpose of the zone is what they're asking. What is the purpose of the shorefront zone?
What, you have a number for that?
No. I would if our book had page numbers in a
I always
table of
look at
contents,
page
but it
numbers.
doesn't.
That's too much to ask for, Audrey.
Yeah, it's apparently impossible.
Well, would it not go back to the application we just had? That was shorefront. Wouldn't I find it in there?
If it's printed in there, yes.
That would have been 175,
62.
64A1. No, 67B. Okay.
Storefront. Article 9. Purpose. The purpose of this district is to maintain the integrity of the existing shorefront residential district and protect the shorefront from overdevelopment. Further, the town recognizes the importance of implementing water quality protection standards in order to protect the shorelands within the town of Wolfeboro, since they are among the most valuable and fragile natural resources and that the protection of these shorelands is essential to maintain the integrity and exceptional quality of waters.
Okay.
So we're talking about the impervious, which is protecting the water. It apparently is not changing. And so the other piece would be to maintain the integrity in the existing shorefront residential district and protect the shorefront from overdevelopment.
Well, just take the first line, maintain the integrity of the existing shorefront residential district.
And I think it does.
Yep.
This is the
And
same.
protect the shorefront from overdevelopment.
Yeah, I don't think this is causing overdevelopment in a place where we don't want to see.
It's a relatively small change.
It's a small change, and it's an area where there's, a compact number of buildings, which actually is not a bad thing when you're looking in Wolfeboro Bay to see all the houses. That's not so bad. If you're out on an island, you don't maybe want to see them all clustered around one area. But this is actually an area that it's not a problem. And this wouldn't even impact that anyway. It's so small.
It's not sticking
So
out
do
any
you
further
think
than,
it does or doesn't meet the definition?
I think it meets. I think it's okay. I think that it meets the first two criteria.
Yeah, I agree. I think it is not contrary to public interest.
And I think the spirit of the ordinance is observed.
Okay.
Agreed.
Kate?
I agree.
I
Jody?
agree.
Brian, yes.
We got a pretty good look at it.
What?
We got a good look at it with the site visit.
Okay.
Small change.
So,
Substantial justice. Substantial justice.
going
Go.
there. Substantial justice, number 3. The benefit to the applicant should not be outweighed by the harm to the general public.
I don't think there's any harm. There's no change to impervious surface. They apparently want a deck, and a patio is much nicer, but that's not for me to say. They want a deck.
Kate?
I agree.
Jody?
I agree.
Brian, yes, I agree.
Agree.
Okay.
Number 4, the values of surrounding properties are not diminished.
There'd be no reason for the
Have
values
any
to be
expert
diminished.
testimony.
Yeah, that's true too.
Number 5, little enforcement of the ordinance should result in unnecessary hardship. Unnecessary hardship can be shown in either of 2 ways. The applicant must establish that because of the special conditions of the property, the restriction as applied to the property does not serve that purpose in a fair and substantial way, and that the use does not alter the essential character of the neighborhood. Audrey, you want to go first?
I think it could be said that the special condition is it's already over impervious surface, and it is not impacting the neighborhood. And the application of this section to this project is not reasonable.
Is not what?
Is the application to the denial of this project based on this section is not a reasonable denial. There's no fair and substantial relationship between this section and the proposal.
So you're saying he doesn't have a hardship?
I'm saying he has a hardship. He has a special condition to the extent that this ordinance doesn't apply to his situation fully. If we bring the full weight of the ordinance onto this situation, that would not be fair. It's not substantial. There's no relationship.
Kate?
I think that's true. I mean, it doesn't make the situation any better, but it does no real harm, so it seems reasonable to allow.
Jody?
It's not sticking out past the back porch, so I think it's appropriate.
Yeah, I don't think it alters the essential character of the neighborhood either.
No.
Chuck?
I agree.
Okay, so does somebody want to make a motion to approve this application with conditions?
Yes, I'll make a motion to approve this application, which is case 20V 25 175-43 1I
A1I.
A1I.
And I will add to your motion, per the plan received August 18, 2025, and the plan of 7/11/24 drafted by Horizon. And then I will also add what is typically the boilerplate conditions.
So where are you getting your dates from?
What?
Oh, it was received on the August 18th. Okay, the date is August 15th.
Okay, yep.
Gotcha.
Okay,
Yep.
all right. All federal and state permits shall be received prior to the construction. I'm not going to read the whole thing. The approval is consistent with the material handed to us dated August 18th, 25, and the plan of 7/11/24 by Horizon. The application as submitted does not satisfy the submitted requirements for the building permit or site plan approval. The notice of decision shall be recorded at Carroll County Deeds, and the responsibility of payment by the applicant. The town records that. The variance shall be valid if exercised in 2 years, in accordance with 674-33, 1A. Appeal process is in accordance with 6772, 6774, and 6796. And that's it.
I think you stated a wrong date. So
What?
stated a wrong date. So could we just verify when this is written up that the application and the plan was received on August 18th and the date of the plan is August 15th?
No, it's right here, August 18th.
That's when it was received. The plan was written on, was drawn on 8/15, but you said something about 7 something.
7/11,
Where did you get that?
down the bottom. Is that not the correct?
No, you have to look in the bottom right-hand corner where it says sheet 2 of 2,
Oh, I
above that.
see. Okay, over here, it's 8, check that date, it's 8/15/25.
Exactly.
Okay. We have a motion with conditions. Anybody want to second the motion as conditioned?
Second.
Roll call vote.
Audrey, yes.
Kate, yes.
Yes.
Ryan, yes.
Yes.
You have your approval.
For that.
Okay, 2 quick items. Thank you.
We got one more.
We got one more. We got the, yeah. Let's go, go.
I keep forgetting.
Should be quick.
Get your second wind.
So now we got the special,
Special
now we have the special exception
Yes.
for the same project on 48 Sewell Road. Chuck, you want to read the legal notice, please?
Yes. This one is for a special exception. Can I clarify something first? Let me clarify the case number for the first one, because actually the agenda is wrong. I realized that too late. The tax map number. The first case was a variance. Tax map number 217-133, not 113. At 48 Sewell Road, case number 20V-25, 75,
175.
175-43A1I is what we just discussed.
Yes.
That's just to correct that case. The case we're going to consider next is a special exception. Michael and Tamara Slode, tax map number 217-133,
Yeah, okay.
48 Sewell Road, case number 19-SE-25, 175-43A1C, application for a special exception, expansion of a second floor above footprint of an existing closed porch.
Okay, so special exception is easier to navigate, and I'm wondering, Mr. Town Planner, can we just accept this as printed rather than have to have him read through the whole thing?
I don't think that's for us, though. I don't think that's a zoning board issue. Yeah. What, I suggest we have him read it, but we speak to each one as he's going, and then we don't have to go back,
Yes.
Okay,
right?
yeah. Okay, stop.
Yes, your mic is dead. Extra?
Is the battery dead?
Let's give him Bill's. You might have to.
So I'll just read this right off of the
Yep.
right off of my thing. So the site suitability, we're going to
Yes.
start with the usable space for this expansion exists above the first floor porch. That shows up in the photo that you saw.
Yeah, and just read your response.
The access to the expansion is adequate through the existing second floor, and the construction will be outside of the special flood hazard area. So that's the absence of the environmental constraint. The immediate neighborhood impact.
Oh, wait, let us comment on that one.
Okay.
I agree with their contention that there's adequate space, access, and absence of environmental constraints.
Okay,
No, I agree, but isn't there a requirement that says he can do that up to 25%? Is that the,
Correct.
so what is the number as far as the expansion?
The number for this expansion is somewhere around 18%.
Okay, thank you.
okay. I agree that the requirements under site suitability are met.
Agree.
I agree.
Okay.
Me too.
Number two,
Number two, the neighborhood impact.
can you
There's-
just read what you put down?
Yes.
You don't have to read A, B, C, D, E.
The proposed expansion will not contribute to additional trips by vehicles, nor will it create any of the other impacts, noise, dust, smoke, inappropriate hours.
And I would comment for the record that this is pretty much non-applicable with this type of expansion.
I agree. I agree.
I agree.
Number three,
The reconfigured driveway, and this, maybe the planner can look at that. We've taken out the loop from the driveway, and the driveway as it exists has great sight distance up and down Sewell Road, so it's not a hazard to pedestrians or vehicles.
I
would
can
agree.
verify, because I pulled in and I turned around and I pulled out, and there was plenty of room without the loop driveway.
I don't know why they took the loop driveway out, but I like it.
But actually, that has nothing to do with this special exception.
Yeah.
The special exception is for an expansion over an existing porch, and there's no undue nuisance or serious hazard to pedestrian or vehicular traffic there.
True. So,
okay, I
Not a-
agree. Number four,
Yes. No.
No.
It's nothing to do with the driveway.
I'm saying that driveway is not applicable to this.
Yep.
We have a state permit by notification, but we don't have the town one yet. We're going to have to be going through that, but we wanted to get this done first. No.
Number 4, availability of public services and facilities. Just read what you.
Yep, the site is serviced by town sewer and water. There's a fire hydrant on the street, and there's a stormwater catch basin right next to the driveway entrance.
I agree.
I agree that he meets all public service needs. Number 5, appropriateness of site plan consideration shall be given to the following. And again, you could read what you put and then go ahead.
Yeah, I said that the traffic circulation pattern is modified by removing the loop driveway to eliminate nuisance turnarounds, and the landscaping and lighting on the site is to be unchanged.
Again, number 5 is slanted towards if it was a commercial operation.
Yep.
Fencing, screening, landscaping, signage, commercial vehicles, like, so I think you meet number 5.
Me too. Agreed.
Number 6, immediate neighborhood integrity.
Yep.
That the use and established use patterns be weighed with recent changes in the trends of the neighborhood. Please read what you wrote.
I wrote the proposed use conforms to existing neighborhood trends.
I agree.
Which is.
Agreed.
Everybody's building.
Yeah, I agree. Impact on property values. Again, we don't have any backup information on that. And read, please, what you wrote.
I wrote the proposed use would contribute to an increase in value to both its value and the adjacent properties.
Yeah,
I agree.
reasonable.
Agree.
It either will or it won't matter.
I don't know if it would contribute or not, but it won't decrease, I wouldn't think.
I would agree with what the application says, which is that it should contribute to an increase in value.
Should.
Okay, number 8, the proposed use of structure is consistent with the spirit of the ordinance and the intent of the master plan. Please read.
The proposed small expansion of the structure, that's the deck and the second floor expansion, is consistent with the spirit of the ordinance and barely noticeable when complete.
So another,
Board, do you agree?
I guess, so the percentage increase is not an issue at all because it's below the 25%. So the main reason for granting the special exception or for needing one is because it intrudes into the setback. That's correct, right?
Well, it's not changing any.
Well, I mean, it's putting another story above it.
Yeah,
but it
it
Right.
is- yeah,
It's adding volume.
yeah,
The footprint's already there, they're just.
yeah, okay, all right.
So I think it's consistent with the spirit of the ordinance because we read what the ordinance says in that district, and this doesn't conflict with the purpose of the ordinance in the shorefront.
Make a motion to approve
I'll make a motion to approve
with conditions.
case number, where's the case number?
19, special SE 25, 175-43, special exception.
A1C. It's section 175-43A1C, but I don't know what the case number is.
Tax map 217-13.
133.
133. The case number is 19-SE-25.
Okay.
In accordance with plan received August 18th, 2025, and plan drawn by Horizon on, I had that date wrong.
October
before.
15th.
August 15th.
8/15/25, with conditions. And I'm just going to abbreviate those conditions, which are all federal and state permits shall be received prior to construction, the approval of consent with the material handed in to us, the material that we received on August 18th, 25, the plan of whatever I just said. Oh, God, help me. 8/15/25 by Horizon. The application submitted to the ZBA does not satisfy all the submittal requirements for the building permit or site plan. Notice of decision shall be recorded by Carroll County Deeds paid for by the applicant. The special exception shall be valid if exercised within 2 years of the case of the date or further extended by ordinance or this board under 674-33-1. Appeal process is pursuant to 6772, 6774, or under certain circumstances, 6796. Motion, roll call vote. Audrey?
Second?
Okay.
Yep.
Second that requested amendment by our Mr. Scott. Roll call vote. Audrey?
Yes.
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 Ryan, yes.
Yes.
You've got your approval. Board members, don't go away.
I'm not going anywhere.
One quick thing. The minutes of Monday, August 4th, I have a question to the board. First of all, will you accept them as printed?
I'm sorry, I didn't actually read them.
Well, I make a motion to accept as printed. I read them twice, and then I read them one more time when I got a printed copy. Do I have a second to accept as printed?
Second.
All those in favor? All those in favor?
Aye.
Aye. Okay, the question
Abstain, 'cause I didn't read them.
to the board is, Audrey, you abstaining?
Yeah.
Okay. The question to the board is, do you want minutes done like this, 23 pages, or would you like the format that we typically have, which the scribe highlights the important issues?
I do not want a narrative of everything we said.
I agree with that.
So, question for you. Is it a new person? So the narrative ones typically are done.
We don't have anybody we had before. Let's
Okay.
simplify that
So-
question.
Typically, the ones that are narrative come from a translative computer program, and it narrative, but you can
We don't
ask.
have it, we got a different person totally.
I'm telling you that she probably ran that, and if she did, she can have AI condense it for us into bullet points and
I'm not
important
going to tell,
things.
we have our Mr. Town Planner that is the head
Okay.
of our department, and
Just
I
a
would ask
suggestion.
him, please to speak to the transcriber and set up a format that you have sort of heard from us.
Yeah.
Okay. Yeah. And with that AI, this person that's transcribes can, well, I don't know, but this person can interject into AI things that she thinks are more relevant.
No.
Well, then you'll take care of it for us. I don't care. The only thing I care about is that we keep these line numbers. That's very, very helpful.
So the important things, as we know, is the 5 criteria in our reasoning, and then the findings of fact that we have to come up with, and our votes and our motions. Yeah.
Well, the minutes have to be done in 5 business days, and I think that the notice of decision has to be done in 5 business days, so you won't have the minutes. Really? Yeah, okay, all right. And he has graciously agreed to do the findings of facts for us, because we haven't done them. Yeah. We're supposed to do them.
So is that like the notice of like the minutes, can we review and approve the findings of fact rather than have it be like the decision which we don't change unless there's something wrong with it?
No.
Can we do that electronically? Can we review the facts and make any notes that we want? Yeah. Right.
Sounds good.
Exactly.
That
Yep.
shouldn't hold up meeting the 5 business days. We've been very delinquent.
I would like to be able to verify the findings of fact with what I believe I said or found that's factual or heard that was factual.
Well, I don't think we have the worry that we used to have, and I'll leave it at that.
I don't disagree with that. Nevertheless, finds the facts. Yeah.
Okay.
You can write the minority opinion.
Okay.
Okay.
Thank you.
I
All
move
right,
to adjourn.
Motion to adjourn.
Thank you.
Motion to adjourn. Second. All in favor? Yes. Okay.
I